Okay, so we're back here again. This is 508. We continued from this week a discussion about negligence, went into great detail about that. So that discussion is concluded. We're now going to talk about very briefly, and the Mallory book gives very, very limited space to it, so we'll deal with that in that regard here too, is strict liability. And what is strict liability? It is essentially liability that's established without regard to fault. Remember that in negligence we try to establish, is there a duty, is there a breach of that duty? In other words, did somebody fail to do something or do something below what would be expected based on what the standard of care is? Strict liability is different. It's going to impose liability regardless of somebody who's the defendant messed up or not. Now, this imposition is a social policy. It's a decision by policymakers. It's codified in statute and the common law that the risk associated with a particular activity should be borne by those people that pursue it. And we see it coming up in a couple of areas. It's imposed in two primary activities. One, in abnormally dangerous or ultra hazardous activities. So one is abnormally dangerous / ultra hazardous. Second is the manufacture or sale of defective products that are unreasonably dangerous. Those are the two instances we see it coming up. Abnormally dangerous activities, think in terms of obvious stuff, blasting, crop dusting. Those are some of the examples that are mentioned. Those are by no means, the only ones, but some examples. In terms of products that are defective and unreasonably dangerous, a product, say, for example, that is a power tool that may be defective in some way and then therefore causes this unreasonable danger. So you want to always look at the very specific facts to determine, could it be categorized in either an abnormally dangerous activity, or is it a product that is defective and unreasonably dangerous? Those are the buzz phrases. We'll take those terms and we'll utilize them to facts as they may come up through the semester. But the emphasis here, based on how this information is conveyed here and in the book, we're going to allocate very little time or less time to strict liability. There's some information here about tort reform. You should read that, but we're not going to be covering that per se for anything relating to final exams or midterms. So that pretty much concludes the tort section. I wanted to as I mentioned in class, briefly cover some of the remaining elements of contracts. Again, we started with contracts in the other online lecture, where we pretty much went through all the basic elements: the foundation of contracts, offer, acceptance, formation, consideration, and talked about other related elements. What we want to go over here is the remaining elements that are captured in the book. It's very, very high level stuff. I'm going to really fly through it quickly here. So chapter 13 talks about the reality of consent, and it discusses some of the things actually that we had previously talked about in our discussions. Particularly, we may remember we got into the question of fraud and misrepresentation in the context of the Bedbugs hotel case. Here it's represented in the context of contract law. Is there some misrepresentation or fraud in connection with the negotiation of the contract? Here it can come up in the context of, would you have entered into the agreement but for certain promises that were made by the other party? If those promises prove to be based on some misrepresentation of a material fact, some sort of fraud, you could have a basis for voiding the contract, suing the other party for damages. Page 389 talks about the requirements for rescission, meaning to undo the contract on the grounds of misrepresentation. Again, we talk further about some of the elements of misrepresentation. You've got to have some untrue assertion of a fact or failure to omit a material fact. It's a materiality requirement. You actually have to rely on it, and that reliance has to be justifiable. Another element that could affect or void the consent in connection with a contract is some form of mistake. Was there a mistake of some kind? The effect of a mistake, the mere fact that there's the contracting parties have made a mistake is not a sufficient basis by itself for avoidance of the contract. But one important factor that affects the right to avoid is whether the mistake was made by just one of the parties or by both of the parties. If there's some sort of mutual mistake, some sort of clerical error, the contract can be reformed or reconstituted or redone. A mutual mistake, however, that is maybe more significant than that, has a few elements to it, and the book highlights three of those on page 393. The mistake relates to the basic assumption which the contract was made. The mistake was a material effect on the agreed upon exchange, and the party adversely affected by the mistake does not hear the risk of the mistake. The concept review box on page 393 highlights, in the event of an innocent misrepresentation or fraud, talks about the elements and what those remedies are. Page 394 goes into requirements for unilateral mistakes. Page 396, duress. Duress is basically, as its name suggests, some sort of threat, some sort of coercion. If there's a duress, some form of a duress in contract, that is a basis also to void the agreement. 397 highlights a couple of the elements. The contract was induced by some improper threat, or the victim had no reasonable alternative but to enter into it. Take a look at the concept review on page 399. There's elements of coercion, elements of undue influence. Chapter 14, capacity to contract. Capacity just means the ability to enter into an agreement. Do you have either the mental capacity, people who are insane or not in a position to have all of their mental faculties, typically will not be, or almost always will not be in a position to be deemed to have capacity or the ability to enter into agreement. I think we talked about this in an earlier lecture. Age is also an element. Minors do not have capacity to enter into a contract. You can't go into and enter into some sort of an agreement with a 3 or 4-year-old and expect a court to enforce it. Court would say, no, that individual just doesn't have adequate capacity. You've got to be at least a minor, which is over the age of 18. Intoxication, the same sort of thing. If you're heavily intoxicated with alcohol, drugs, or some other, or say you just come out of a surgery and you're coming off the effects of the anesthesia, you can't be given papers to sign and sign your life away. That won't be deemed enforceable. It'll be a capacity issue, and you'll then have the ability to disaffirm or reject that agreement. Chapter 15, illegality. You cannot enter into agreements that are predicated on some illegal transaction or premise. You can't enforce an agreement for the sale of crack cocaine. Crack cocaine is illegal. You can't enforce agreements. If you enter into the old mafia movies to take somebody out, to kill them, you can't then say, well, the hitman didn't perform their job, and therefore I'm going to go to court and try to enforce that. That's obviously absurd. That's an illegal. Murder is illegal. The court is not going to enforce that. So these are just very, very common sense sorts of things. I'm really not going to get into much else, other than pointing out also on page 420 of the illegality section, there are certain other types of agreements that are maybe a little less obvious in terms of their illegality. Agreements to restrain competition, and this is important to spend a little bit of time on. Agreements that restrain competition will be scrutinized very closely. That doesn't mean they're on their face illegal. Let me try to add a little color to this. Competition law is going to be governed by federal law, around antitrust issues and things of that nature, although there's state antitrust laws too. But there's also competition laws around employment issues, restrictions on employment. Those will typically be governed by state laws. Overarching view is, restraints on trade, the Sherman Act specifically, sections 1 and 2, those are federal law and will be obviously enforced and are designed to promote competition. The idea is we want to have competition in our system. That said, there will be certain instances where restrictions on competition, restraints on competition, will be upheld if they meet certain tests. Let's talk about employment law, for example. Specifically, employment law is a state-by-state analysis. It's going to depend on which state you're in, depending on which state law will govern. But fundamentally, say we're in California. California will have employment in this class. Employment law is typically thought to be a very pro-employee state. So in California, non-competition restrictions in employment context are prohibited, except for very limited circumstances. If you're selling a business, in connection with the goodwill of the sale of a business, you can have restraints placed on you for a reasonable period of time. But you're, like most of us, regular employees, an employer cannot impose such a restriction on you. They cannot restrain your ability to work for one of their competitors. If you're working for McDonald's, and McDonald's here in Northridge, one of the franchises, they can't place a restriction on your ability to go work for Burger King. They can't put that in your employment agreement. They can't put that in another agreement that they require you to sign to be employed. That would be void, and that would be an unfair restraint on trade and unfair competition, and violate public policy and would get them in a whole lot of trouble. Now, California is one state. Other states, and indeed most other states, don't have such a restriction in the employment context. That is, most states, Arizona, plenty of other states, New York, Connecticut, Texas, allow for these non-competition restrictions in the employment context, but there's got to be some specific limitations around it. So what are those limitations? The first is it's got to serve a legitimate business purpose, meaning you can't just put someone on these restrictions simply to punish them or to harm them or to really restrict their ability to earn a livelihood. You have to assert that there's some very specific business purpose why you need to do this. You may need to protect some of your trade secret information. You may need to have a legitimate purpose to protect certain elements of a very important aspect of your business. But the more narrow that legitimate business purpose is, the more likely that it's going to be deemed to be enforceable by a court. So if you're on the employer side, you want to narrow that. Secondly, it must be reasonable in terms of time and geographic scope. So what does that mean? You can't have a non-competition restriction. Say if you're employed by McDonald's, and again, it would apply in California because I said it's really not legitimate or legal in California. But say you're in another state like New York where it is. You can't have that non-competition restriction with McDonald's to join a competitor and put that out there for 100 years. First of all, the person won't live that long in all likelihood, but secondly, that would be deemed to be far too excessive in terms of duration of time. So what is a reasonable duration of time? Reasonable duration of time, anywhere from, call it, 6 months to 2 or 3 years. Once you start getting much beyond that, courts, I think, are going to really start to scrutinize. it a lot more carefully. What's reasonable in terms of duration will depend on the circumstances, will depend on the industry, but just know it can't be for some ridiculously long, indefinite period of time. It's got to be a specific, definite period. And again, in terms of enforceability or likelihood of enforceability, you're going to want, if you're a company, to construct something that makes sense for your business, but doesn't go so far out that it's going to be deemed to be unenforceable. So which seems to suggest the shorter period, the lesser the period, the more likely it's going to be enforced, which I think makes perfect sense. So reasonableness as to duration. What else? Reasonableness as to geographic scope. What are you going to say? The entire solar system? I mean, that's obviously, over the top and extreme and doesn't make any sense. If you say the entire world, that also is going to be over the top and excessive. So how do you narrow it? You see a lot of these non-competition restrictions that talk about North America. That's probably almost certainly too broad as well, because you're talking not just about the United States, you're talking about two other countries, Canada and Mexico. So then you'll see something as well, the United States or the 48 states, exclusive of Alaska and Hawaii or something like that. That's probably too general and broad as well. So you want to narrow it further. If you're a New York company, maybe you narrow it to New York. Better yet, if you could narrow it to, a geographic area, a radius of area, 35-mile radius within the headquarters of where that company is, something like that. The narrower it is, the more likely it is to be enforceable. But you've got to place some limitations on it. So reasonableness as to geographic scope, reasonableness as to duration and time, and of course it has to serve some legitimate business purpose. And it should not impose any undue hardship on the individual, which, kind of by its nature it does, right? So, how strong or how far is that undue hardship is. And courts again, are going to really scrutinize this, because the basic assumption is that we all have a right to earn a livelihood, and that companies and employers should not impose restrictions that legitimately restrict someone's ability to earn that livelihood. Now, one other point to make, which I don't think was as clear as it could have been, and it's not really so focused in the book, is another element you want to put in is narrow the description of the business. So, for example, back to the McDonald's Burger King example, suppose you're in a jurisdiction where non-competes are enforceable. If I'm at the McDonald's proprietor and I want to limit them from joining a competitor, I say I have a reasonable duration, say 6 months. I say it's limited to this 35-mile radius in this area. Fine. So do I then say you're prohibited from working for anybody? No, that's way too broad. What if I said you're prohibited from working for any restaurant? Well, that's probably too broad too, even though McDonald's, Burger King are restaurants. How could you narrow that further, right? You could maybe say something like, limited to fast food restaurants, or limited to, maybe even more, major national chains that are fast food restaurants. You wouldn't want to maybe preclude them from working for some, single person, sole proprietor burger shop somewhere, or at the student union that may happen to sell burgers and could conceivably be considered fast food. So those are a lot of the things to think about. Overly broad provisions like that will be stricken, and as I said, courts will look at them very, very closely. Unfairness in agreements. I'm now at page 425. Contracts of adhesion, unconscionable contracts. Unconscionable contracts, again, are those contracts that are so far-reaching in their level of oppression, really. They're just imposing such severe consequences on the other party that they could be undone or deemed to be unconscionable and then rescinded or reformed, meaning modified or changed. The concept is impossible really to define with precision, but it generally means the absence of any meaningful choice together with some unreasonable advantage to one of the parties. So really think of it this way. In plain English, someone's really jamming you on something and you have really no choice but to sign. I mean, it's got an element of duress, for sure, maybe in the execution of the agreement, But the agreement itself is unconscionable because you had no choice to really go into it, and the terms are so one-sided to that other party that they're considered to be unreasonably advantageous. And then in the context of the UCC, it cites the unconscionability provision 2-302. So please take a look at that. And contracts of adhesion are usually on standard forms, what we'll call, back of those agreements that you have when you deposit your car to be dropped off. When you're at the restaurant, you give it to the valet. Your agreement with your cell phone provider, etc., your cable provider. It's kind of a take it or leave it proposition where the other party has some superior bargaining position. You have no provision, no opportunity really to negotiate what those terms are. You could argue that really a lot of contracts we sign are contracts of adhesion, and that's an argument that you frequently see when there are suits. They often do not succeed when I've seen them, but you should know that that's at least a defense or claim, not a defense, a claim that you could raise when you're given these sort of one-sided agreements where you have no contract or opportunity to negotiate. Again, you typically see that claim in the context of provisions that are so over the top that it's not only a claim for contract of adhesion or contracts of adhesion, but unconscionability and other sorts of things. If there's elements also of forcing you, kind of putting your gun to your head to sign, that's also an element of duress. So there's a good chart on Figure 1 on the illegality of contracts, or when there is illegality, what the sort of the process flow is. So take a look at that chart on page 430. Now, writings. You've obviously got to have a contract. I think we've determined that not all contracts, however, need to be in writing. And indeed, an oral contract is as enforceable as a written contract, except for certain contracts that must be committed to writing if they are to be enforceable. And that's what we call the statute of frauds. The statute of frauds. I'm not going to spend a lot of time on it. However, you need to understand the basic concept behind it. Take a look at page 435. A contract deemed to be covered within the statute of frauds, meaning it has to be evidenced in writing, is covered within largely the following 6 areas. 1, collateral contracts in which a person promises to perform the obligation for another person. So this is where you interject really a third party into the process, where you don't have a contract with you have a contract with one of the parties, but the performance obligations are going to be done by some third party. There the courts are saying, no, that can't be an oral agreement. That will not be enforceable. You have to commit it to writing. Second, this is where it's going to come up in most of your situations. And this is where we spend a lot of time, say, in law school studying. And that's number 2, contracts for the sale of an interest in real estate. Every first-year law student is going to learn this and know when you sell real estate, when you buy real estate, you need to have it in writing. It cannot be an oral agreement. A lease for an apartment that you're renting, in writing. So anything pretty much that's connected to real estate, your bell should go off. Statute of frauds, statute of frauds, statute of frauds. It needs to be in writing. An oral agreement will not cut it. Third, bilateral contracts that can't be performed within a year of the date of their formation. So again, you have these agreements where, again, you say you have a valid offer, acceptance, you have the formation, you have adequate consideration, it's not illegal, parties had adequate capacity, blah, 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 blah. It has all these elements. Okay, if the contract, however, if the performance obligations cannot be performed within 1 year, if it's longer than 1 year or they're pushed out from a year from the date of formation, it also needs to be in writing. Contracts for the sale of goods is where the UCC comes in. Contracts for the sale of goods for a price of $500 or more. So if you're selling goods, if you're merchants or even if you're not merchants, if you're selling for $500 or more, if it's a good, it's got to be in writing. Contracts in which an executor or administrator promises to be personally liable for the debt of an estate. Yeah, that's probably a good thing, right? Where the administrator of an estate, the executor of an estate promises to do something to be liable for that debt. That should be in writing. And contracts in which marriage is the consideration. So things involving marriage should be in writing. So these first four sorts of contracts have the most significance today, and our discussion, or the discussion in the book, focuses on those first four. I mentioned particularly one of those four, which is the real estate, and that's what I would like you to focus on when you go through this. But that's pretty much the main summary. Take a look at page 442. That has a very good recap of what we just went over, and also take a look at the chart on page 445, satisfying the statute of frauds for the contract for the sale of goods for $500 or more. That gives you some further idea. The parole evidence rule is an important rule. I wish I could cover it now, but in the interest of time, we will skip it. That's all that you really need to know with respect to that. Rights of third parties is also a significant area. When you're talking about assignment of rights, assignment of contracts, typically you can assign an agreement if the contract allows for it. The person doing the assigning is called the assignor. The person who is receiving that contract is called the assignee. There's also the terms obligor and obligee. The obligor is the person who owes the duty to perform. The obligee is the person who has the duty or the obligation or the right, more precisely, to receive that obligor's performance. That is reflected on page 457. In the context of what we're doing here, I think particularly in terms of the scenario, the fact pattern scenario that will be going on throughout the semester for the group project, just think in terms of, are there any obligations that I have, if you're either Team A or Team B, where I can assign potentially my rights or my obligations to another party? What obligations also would I have as an obligor to perform, or as an obligee to receive some of that benefit of the performance? So think in terms of those concepts. It'll come up potentially in how you negotiate your non-disclosure agreements, how you maybe negotiate your agreements, and how you actually perform your specific obligations and duties in connection with this scenario. Chapter 18, performance and remedies. We do need to cover a little bit, and again, like this other stuff, we're going through it very, very quickly. But it is important for you to get a good handle on at least some of the basic concepts. The first thing is the notion of a condition. Condition is a situation which sets a series of things that have to happen before the legal obligation kicks in. So, very specifically, you could have a condition precedent, meaning a condition that has to happen before the legal obligation kicks in. So you could say this contract is not effective until this happens. So for example, what's the this? It could be whatever the parties really agree to, so long as it doesn't violate some sort of public policy or isn't illegal or isn't otherwise enforceable. But say, for example, you enter into this agreement. You enter it today, which is September the 10th. You enter it September the 10th, but you say, a condition precedent to this contract being effective, or condition precedent to this contract actually requiring a performance obligation, is the deposit of $50,000 by Party A under this agreement. That would be deemed a condition precedent, something that has to happen in the future that creates a duty to perform by one of the parties. So again, you're entering into the contract today. You have a binding contract. However, this future event that hasn't happened yet has created some duty to perform, and we call that a condition precedent. If the condition doesn't occur, the performance does not become due. So Party A has to deposit the $50,000. If that condition precedent is not satisfied, Party B doesn't have to do anything on their end. Whatever performance obligation that might be, deliver the services, start performance, whatever. Party A doesn't make the payment, no obligation. Party A makes the payment, condition precedent has been satisfied, the performance obligation of the other party kicks in. Concurrent condition is something that is a performance obligation that happens essentially simultaneously at the same time. So the book gives the example. Martin promises to buy Johnson's car for $5,000. Martin's payment of the $5,000 and Johnson's tendering of the $5,000 of the car both constitute the concurrent conditions of performance. Condition subsequent is interesting. That's a condition actually that discharges a duty to perform if it happens after, or it happens at some point after the fact. So when a duty is subject to a condition subsequent, for example, the book gives, Wilkinson and Jones agree that Wilkinson will begin paying Jones's $2,000 a month, but if the XYZ Corporation dissolves, Wilkinson's obligations to pay will cease. So if that condition subsequent occurs, then the performance obligations stop. Note how it's somehow related to condition precedent, but it's actually quite different. In the case of condition precedent, something has to happen. Someone has to do something. Some event has to take place for the performance obligations to continue. Here, the parties are performing, but if some other event occurs, the performance obligations at that point of one of the parties cease. In this case, if he fails to pay, or if as he's paying the $2,000 a month, if the corporation dissolves, those obligations stop. So please take a look at that, page 474 and page 475 in particular, the effects section under Figure 1. That's about all we'll probably cover on conditions. Performance of contracts, obviously you have a good faith to perform. That's kind of, you got to substantially perform. If not, you'll be deemed to be what's known in breach. That's B-R-E-A-C-H, meaning you haven't performed your obligations. And we're going to look, when we look at breaches, we're going to look at material breaches, meaning significant things, bigger things, not tiny little things. So, what would be the difference? Okay, you've got a performance obligation, say in your agreement, performance obligation to deliver something within a specific period of time. Say, I've committed to deliver something at, by no later than midnight on the 10th. Well, suppose you deliver it at 12:01. Is that going to be deemed to be a material breach? Probably not, unless the parties knew in advance and explained in advance, no, if it doesn't arrive by 12, I can't then deliver it to my other client, and therefore I'll lose all that business, and therefore it will be basically valueless. If the parties understood that, agreed to that, then yeah, then that very likely and almost certainly would be deemed to be a material breach. But these ticky-tack little things, these small little things generally are not going to be material breach. We're looking at bigger things. That's hence the word material means, big, significant, larger. So take a look at that. I think the reading do a pretty good job of trying to explain that. So that'll highlight further what I've just tried to describe. There's this notion of anticipatory repudiation. That is a type of breach when the promisor indicates before the time for his performance that he's unwilling or unable to actually perform. That's what's known as anticipatory breach. That too constitutes a material breach of the agreement that discharges the promisee from all further obligations. So, Party A and Party B have this agreement. Party A starts performing and says, you know what, I'm really not going to be in a position to continue performing for much longer. I'm really not satisfied here. That then is putting the other party on notice. This guy's about to breach, so you yourself are no longer obligated to continue performing. That's what you would allege is an anticipatory breach. What is the recovery for parties committed a material breach? Well, I mean, the obvious one is we talked about money damages, right? That's something you could always try to seek. We went through what those different money damages could look like. You had actual damages, potentially consequential damages. Those we saw when we looked, for example, at the Amazon terms. Parties typically will try to carve out or exclude these indirect or consequential damages. But still, you could also try to pray for that. So that's take a look at what's there. There's always going to be defenses. What are some of the excuses or bases for saying I couldn't perform? You could say, well, it was impossible. It was impossible, meaning I was unable to do it, not because of I just didn't want to. It was impossible in sort of the colloquial sense, but really there were events that made it impossible for me to perform. There was some supervening event that occurred, whether it was the death or severe illness, whether it was some change in the law that precluded me, some regulation that precluded me from performing, literally made it impossible for me to perform. If there was a riot or a strike, a massive earthquake, I couldn't perform. It was impossible for me to perform. So that's what we generally under the category of impossibility. Within that, we have different types of elements. One is, illness or death of the promisor, supervening illegality, if the subject matter of the contract is destroyed, those sorts of things come in. Under the UCC, there's something known as commercial impracticability under Section 2-615. Take a look at that under the book. Take a look also at page 488 and 489. Again, what are the remedies? Legal remedies for breach of contract, money damages. We talked about equitable remedies, right? And there's, really kind of three types: specific performance, injunction, and rescission. Not going to go over those. We went about that already. And then the third is a new one, restitution, and that requires the defendant to pay the value of the benefits that the plaintiff has conferred to him. That is good review on the damages. Take a look at page 490 where it talks about compensatory damages and consequential damages. Pretty much covered those already. Incidental damages, which are other things that are picked up. Liquidated damages. We talked about punitives, but didn't really talk about liquidated damages. What are liquidated damages? Liquidated damages are pre-agreed damages. So you sometimes see this in contracts where parties, and it's kind of a nifty little tool, where parties will specify on the front end of the contract saying, hey, let's put in a dollar amount that if the other party's in breach, they have to pay us this damage amount. So I don't have to go to court and prove what my damages are. The parties will have already pre-agreed at the contract formation stage what that would be. And that's ultimately contained within the contract, which hopefully would be a binding agreement. So you can see how that might create more certainty for the parties. They know what they're getting themselves into if there's a problem. You got to be careful, though. The downside is if the liquidated damages is of such an unreasonable amount, it could be deemed to be a penalty, and penalties are void or voidable by the courts. The idea is the liquidated damages have to try to, as best they can, remotely approximate what those damages might be under the circumstances when we entered the agreement, or at least what we thought those damages might look like. So it's an interesting tool. Please do consider it. Okay, so that pretty much concludes our contract section. We have a section on sales as well. You will be required to read that. It's still on the readings. But remember, sale of goods is covered by Article 2, and we pretty much highlighted a few of the relevant sections. The unconscionability section, 2-302. We've already just outlined what, when the UCC kicks in. It involves transactions concerning the sale of goods that was covered in the first contracts lecture and discussion. So at a very high level, just take a look at Chart 1 on page 503. Know that, there are higher standards under the code when merchants are involved. In particular, take a look also at the concept review on page 506. That's a very good summary of the formation of contracts overall, which we've pretty much covered already, but I want you to take a look at that. The other element that we covered in the last lecture on contracts was, what do you do when there are new or additional terms under the UCC? And I won't go over those here. I think that's 2-207 if I'm not mistaken. But please do take a look at that. You will be held accountable to that. Beyond that, I think that we are pretty much done with the UCC. Please do read that chapter 19. But beyond that, there's no further elements. And here I think is probably a good place to end this section. We'll come up in a moment and pick up with a new tape on business organizations and entity formations.